Our client came to us. The person who passed away was her mom. Her mom was not married, and our client was one of 3 children. Now, the main asset that her mom had was a home, but there was one of the 3 children that was living in the home.
Okay.
And she didn't want to leave. And our client received a letter from an attorney that was representing the ex-husband of her mother. So after his father's passing, he sent his own demand letter to his oldest brother and said, "Hey, you need to send over a copy of Dad's will. I need to see it." He still got no communication. He came to our office and he didn't know what to do, but Andrew's been helping him through that, one of our attorneys, Andrew, and he had a really good strategy. Hey guys, welcome to Probate Matters. My name is Jenny Dinker. I'm our client onboarding manager with Georgia Probate Law Group and Guardian Probate Law Group.
And I'm Eric Broel. I'm the founder and CEO of Georgia Probate Law Group and Guardian Probate Law Group. Thank you for joining us.
Before we get into all the episode today and all the details, I wanted to remind you guys that I'm not an attorney. Eric is an attorney with our office, but none of the information that you hear today is legal advice. It's just general information to discuss some situations. So Eric, we help people every single day, and we help them settle their loved one's estate, help them close out a really difficult chapter of their life. I thought it might be really helpful for our clients if we shared some actual cases that we've handled at the firm to give our listeners an idea of what our clients have went through and what strategies our team has came up with.
Yeah, I think it's a great idea.
Yeah. So Eric, we help people every day settle their loved one's estate and close a really difficult chapter in their lives. I thought it would be helpful to discuss some actual cases so our listeners can really hear some cases that we've helped our clients with and dig deep into some of these probate situations. Now, of course, we've changed the facts of the case, the client's identity, for the client's confidentiality because we take that very serious.
Yeah, absolutely. And just to speak on confidentiality for a minute, I think it's super important. So the attorney-client privilege is in play for every client that comes to us. Attorney-client privilege and attorney-client confidentiality. They're 2 different rights a client has. And so when we talked about doing this, it's the kind of like the old TV shows. We've changed the names to protect the innocent. So we did modify factual scenarios, and we did modify some things in here because the scenarios we chose to use are interesting, and they're also scenarios that I think we can use to teach a little bit. But it was very important to us and to our firm that we protect the clients that have entrusted us with their case. So we have made some changes to the facts so that we can talk about them, and we're obviously not going to use the client's name.
So we have our first one here that I was going to go over with you. It's actually a case that our senior attorney, one of our senior attorneys, Stacey Ferris, she did a fantastic job with. Now, Stacey's been with us for, oh my goodness, over 5 years, I believe, but she's been practicing law for over 25 years.
Yeah, I think so. Yeah, well over 25 years.
Yeah, she's fantastic. And in this situation, it was a really complicated situation. So our client came to us, and the person who passed away was her mom. Her mom was not married, and our client was one of 3 children. Now, the main asset that her mom had was a home, but there was one of the 3 children that was living in the home.
Okay.
Not our client,
Yep.
but another child of the mom that had passed, was living in the home. And she didn't want to leave. And the home was solely in the decedent's name, the mom's name. Our client said that there was a cousin that was named as the executor in the will. She did have the will, and the cousin was named executor, but the cousin didn't want to serve. There was no one named next, and even our client didn't want to serve.
Okay.
She just wanted somebody to take care of this. She wanted the brother out of the home. She wanted to make sure that the home was sold and split equally like the will says. But she also didn't want to, really ruffle feathers with the brother and didn't know what to do. So Stacey came up with a really good strategy for her.
Yeah, absolutely. Stacey's just such a great attorney. I mean, I've seen her do this so many times. Really, where she's able to pull these really great results out of cases where, quite honestly, we probably should have lost, right? Because the facts weren't on our side, but she's able to, just through the way she goes about looking at a case, the way she goes step by step through it, very, very methodical in how she does each part of the process. And so here, this is a great example of a tough scenario. Much like this client, many people we talk to, they just want to get the estate done. They want to get it done. They want to get it done the right way and honor the wishes of their loved one, but at the same time also move on and close that chapter. I don't want to say that in a callous way, but that's often a concern, right? I want to honor this person, but I also have to continue my life. And so that's a very common motivation. But unfortunately, sometimes you've got other family members that have a different interest. I'm not going to say, they're bad or evil or whatever. They just have a different interest. In this case, the other family member is living in a house that they're not having to pay rent on. That's wonderful, right? Anybody would want to be in that situation. And so this person wanted to continue to live there and not have to move out. But unfortunately, after the decedent passed away, where they were living, where this person was living with their parent, once that parent passed away, we've got to handle that person's house. And there were 2 other siblings here that needed to be involved in that, and they needed to get whatever share they were entitled to. And so here, the strategy Stacy put together was obviously take a look at the will. That's the first thing you always want to do. Make sure you understand any rights that are given in the will or any inheritance, because wills can have a lot of different provisions. Mm-hmm. So she did that. Then we have a conversation with the client, went through the 3 phases of an estate, walked through the will with the client, described the situation, and then identified what she had found in the will. So after consulting with the client about this, Stacy decided the best path was going to be to try to get control of the estate quickly. And that makes a lot of sense to me. I think that's a fantastic strategy, because if we don't, this could get worse and it could kind of spiral a little bit, and that winds up taking longer, costing more money and whatnot. So what she chose to do was to file a petition for temporary letters and get what we call a temporary administrator appointed. And that's a special type of petition, special type of position that allows someone to take control of an estate really, really quickly. The downside of it is they don't have very much power at all. And you've got a lot more court reporting that's involved in that type of a petition. In addition, if you don't ask for some specific powers you need, or if you don't ask for permission to do some specific things when you file the petition, you can't get it. You got to go file more documents with the court and file another request. Stacy, put together a strategy, identified what she would need, asked for all of that in the initial petition, filed it, got it, and then we were able to move on. Well, one of the things she had to ask for was permission to file an eviction, because otherwise our temporary administrator would not have had the authority to do that. Mm-hmm. So Stacy did it the right way, got that permission, and then went ahead and began the eviction process. And I don't want to sound completely heartless. I'm leaving out details here because we did go to the person, attempted to talk to this family member, attempted to send letters. The client attempted to talk to the family member. There was a lot of discussion there. But then at the end of the day, when that person refused to move and we're in a position of saying, okay, well, what are we going to do legally beyond just negotiation? This is the path that Stacy went down. And so that began to solve one part of the issue. Mm-hmm. Because the first part is we need to get this person out of the house because we can't sell a house with them in it effectively. The second part is when it comes to permanently managing the estate, we had no volunteers. Mm-hmm. The person that's nominated in the will didn't want to do the job, and our client didn't want to do the job because the client was concerned that the sibling living in the house was going to then fight her at every step. It was going to cause a lot of damage to the relationship, like any client. And so, just very, very common concerns. And so what we wound up doing is Stacy wound up putting together a request to ask the court to appoint a county administrator. Mm-hmm. And so a county administrator is a third-party neutral, and that's typically an attorney in the community that then acts as administrator over that estate. So it's a very useful tool for some circumstances. It does not work in every case, but it worked here, and it was appropriate for the case that we had. Some of the the downsides of the county administrator are obviously increased fees because there's a lot more fees coming into the estate because of that. And then county administrators typically have a pretty large caseload, and so it can take them a while to get things done in a case because they just have an enormous caseload. I'm always grateful at how well they manage them. And so that's what happened here. And so all in all, I mean, this is a fantastic strategy Stacy put together, got a great result for the client that met the client's goals, right? Because the client wanted to make sure she had control of the house, or the estate did, that we could sell it. And then she herself did not want to do the job of executor administrator. And so this strategy accomplished those goals. So fantastic work, Stacy.
Yeah, definitely. And I like how you broke it down in that there's not just one issue there. There's actually two issues there. You have the issue of the fact that there's someone being uncooperative and won't leave the home, even though they've been asked nicely, hey, can you leave so we can do what we need to do? And then you have the issue that there's no one that's going to be able to have any structure in the situation, because without an administrator or an executor, you have no structure, because there's no one person who has that legal authority to make those decisions and to actually do things. So she was able to work on both of those items, basically. And I know we don't practice estate planning, but just a thought in this might have been helpful if there would have been a successor executor in the will.
Absolutely.
That would have been named, because that would have helped, right?
Yeah, absolutely. If there was a successor, we would have then had a plan, right? But when you have a will where there's only one and not a second, you typically see three. In a good will, you see a first executor and then a successor for exactly this reason, because your executor could pass away, they could be incapacitated, not able to serve, or they could just not want to do the job. And in this case, it was not wanting to do the job.
Yeah. And I also like how you pointed out that, even though the temporary letters of administration, that petition was helpful in this situation, it may not be the best in all situations. I know that there's some counties in Georgia that I've heard from the attorneys in our office saying that you have to do the same process for a temporary petition as you do a permanent. So it's not right for every case. Absolutely
right. And, because a temporary is supposed to be faster, and it's supposed to come with less notice requirements under the statute. However, judges have authority. Each probate judge has authority in their own domain, their own county, and they can set local rules, local orders. And so we do have a number of judges who have standing orders in place that change how a temporary petition works. And those changes are typically to impose more notice requirements or impose more procedural hurdles, because I'll be frank with you, the temporary petition has been abused. It is an easy petition to abuse if you want to. And so I think what the judges are doing in these situations is they've seen some abuses, and they're putting orders in place to try to prevent it. And so you just have to know which county you're going into and what the rules are that judge has put in place so that you can comply with them. And you can still get the result you're after, but you're going to comply with that court's rulings and the standing orders, because you don't want to go in and think it's going one way and you wind up having to go another way and redo a bunch of work and whatnot because you didn't do it in the way that was complying with the standing order.
Exactly. I could see that with what you said about the potential abuse for the temporary letters in some times, because of the fact that they don't necessarily have to reach out to the heirs for that. And so that gives them sometimes a loophole, I would assume, to try to do bad acts if they're not being upfront.
Absolutely. Because the statutory, if you just look at the statute and the code on the temporary administrator and the temporary petition, you don't have to give notice to anybody. You can go in fully ex parte, make representations in the petition, get the judge to give you an order, and now you're in control of the estate, right? Like here, in this scenario we're talking about, we wanted an order that would allow us to evict someone that's in a house, right? And so imagine you're able to go in, you give no notice to anybody, including the heir that's living in the house. You get authority under temporary letters to then go initiate an eviction against that person. Well, they might have wanted to object. Now, legally, should they keep living in the house? No, they really shouldn't, but they might have wanted an opportunity to object to who's going to be the temporary administrator. They might have wanted to object to the idea that the temporary administrator can get the power to evict, right? Whereas now the eviction process starts and we're over in a different court, in a magistrate court, or trying to do an eviction, and that person's defending there. So in a way, I would see it as as a due process issue if we want to get like super legal about it, because while I think the person living in the house was in the wrong, they should leave. That's what should happen. That person still deserves an opportunity to defend. Maybe the person trying to get the temporary letters is just out to get them, right? We can twist this and we can make this a very negative situation and kind of make a villain here, right? Let's say the person, stepping totally away from this, let's say the person that was trying to get the temporary letters is just really out to get this person. You can see how they can engage in a bunch of more shady acts just to make the person living in the house, just to make that heir's life considerably more difficult through the temporary petition. And so that's why many courts have imposed local rules that require notice that's very similar, if not identical, to the notice that is required for a permanent petition. And then if anyone has an objection to raise, they can raise it right there in probate court. That judge can hear that objection and then rule on it. Pros and cons, the con is obviously that it takes a lot longer when you're having to give everybody notice. It takes a lot longer if there's an objection. So it does start to erode away at the idea of the temporary petition is a very, very fast vehicle. I don't necessarily think it's a bad thing that the courts are doing this, because if we can come in with signatures of everybody who is impacted, all of the heirs and beneficiaries, if we get their signatures on consents and we can present all of that to the court and we can assure the court there's not going to be an objection and we're not trying to do anything bad towards one of these heirs, we can still have an effective temporary petition to allow us to take action very, very quickly. Right now, not if we got somebody living in the house, but another common example of when we'd use a petition like this is an impending foreclosure or something like that, right? So now we have a bank that's trying to foreclose on the house, and oftentimes the bank will not talk to anybody until someone has authority from the probate court to act on behalf of the estate. That's another common scenario where this temporary petition gets used. And in that one, there's no villain, there's no ill motive. We can get signatures of everybody involved to say, yes, we are all on board that we need to take care of the bank. We don't want to lose this house.
Yeah. That makes sense. That definitely makes sense. Yeah, and I could see how, but when we're able to use it, I could see how it could be very helpful in some of these situations with the temporary letters. So I'm glad that she did that. That's a big win for the client.
Absolutely. Yeah, big win for the client. I think it's a great case result.
Yep. All right, Eric. So here is a case that's really interesting. Our senior attorney, Stuart Bagley, he's another senior attorney in our office. Fantastic. Love Stuart. This was his case, and he did a great job on it. So I want to give you the facts of it, and you can kind of go over what Stuart decided to do.
Okay.
Cool. So with this client, they had a situation in which her mother had passed away. The mom passed without a will, and the client was the only child of this mother, of her mom. There was no other children, and the mom was not married when she passed away. She got divorced many years before, but was not currently married. And our client received a letter from an attorney that was representing the ex-husband of her mother, and he wanted to be the administrator. So this attorney wanted our client to sign documents allowing him, the ex-husband, to be administrator and control the estate. The estate had financial assets, no real estate, but the client obviously was not comfortable with this at all. She reached out to us for help, and this is where Stuart jumped in.
Yeah, what an interesting set of facts, because just initially, Stuart's a fantastic attorney. He is so methodical with his cases. He goes step by step by step by step by step. And in this world, that's what you have to do. And so I'm very impressed with the results I've seen him get over the years. And this is just, another example of that. This case is interesting because of the ex-spouse element. You wouldn't expect that. Right. And there's even statutes that talk about how if you're the ex-spouse of a decedent, you're not eligible for certain things in the estate, like you're not eligible to serve. And so and even if there's a pending separation order or something like that, then you're not eligible to serve as an executor, administrator, or whatever. Right. It puts you in a much, much, much lower category. And so here, Stewart's strategy was again methodical. So he first took a look at the letter, from this attorney, the corresponding documents, and then began his investigation before he reached out, because it's just the way that the case had started. Mm-hmm. With this other person who shouldn't even be involved, kind of being aggressive towards a heir of our decedent here, was just kind of weird, right? It was one of those odd situations. So he decided to do an investigation first. And so what he turns up, he goes looking through all the court records and whatnot. And what he turns up is that the other side had already filed letters of administration. They'd already filed to try to open the estate. They hadn't served our client or told our client. They just are sending our client blank documents and saying, please sign this. And for the record, don't sign a blank document. Like, that's just general life advice. Don't sign a blank document. And so he figures this out. So then, after consulting with the client, showing the client the evidence that he'd turned up, the decision was made, we're going to go to the other side now. So Stewart sends a demand, a pretty strong demand letter to the other side, and wound up having the other side completely dismiss their petition, so that we could file our petition and not be in a situation where we've got competing petitions. Now, before they dismissed their petition, in addition to sending them a letter, Stewart went ahead and filed a formal caveat and formal objection in the case, to let the other side know we're serious. Mm-hmm. And I think that that's super important. When you're in litigation, some folks threaten things and other folks just do things. And one of the things I love about our team is we've got a really good instinct of when to do each one, but a lot of times you just do something versus threatening somebody with something. And so he just went ahead and filed, and that really shoved the other side backwards, and we got a dismissal out of it. I mean, that's that's not what you expect. I don't want to set bad expectations for anybody. You don't get dismissals all the time in cases, but this is huge that his initial push of a really strong demand combined with a strong objection caused the other side to just dismiss, paving the way for us to get our client appointed, who's really, the only person that should be involved in this estate anyways. They're the sole heir, and then allow the estate to proceed forward. So I love this strategy, and I love the way it worked out.
Yeah. And how you said that our team really, they know when to move forward on some things. I've seen it time and time again in the office where and every situation is different, of course, but if a client has already tried on their own to demand things and stuff like that and it's not working, our team may tell them we need to get more aggressive than just demanding, because obviously demanding's not working, so we need to take that next step. And it sounds like Stewart did both. He demanded and he did what he needed to do.
Absolutely. And that's just depth of experience. With anything, that's just depth of experience. When the average attorney in our office handles 70, 80, 90, 100 cases a year, when our office in total is handling, 500, 600, 700 cases a year, however many it is, you just get a depth of experience, and you have instincts, and you just, in anything, it's not particular to what we do, it's just any person that puts that much time into something, whatever your vocation is, whatever your profession is, when you dedicate that level of time and effort to becoming a master at one thing, you master it. And you get instincts for how to guide clients, how to handle situations with the opposing side, handle situations with courts. And I just think our team is fantastic at that.
Most definitely. Great. All right, Eric, I wanted to go over this one also. This is another case study, and this client reached out to us, and his father had passed away. He was one of 5 children, and after his father passed away, he had actually asked his oldest brother about the will. Now, him and his siblings, they didn't have a good relationship, and we hear this often in our office, unfortunately, is that the family relationship wasn't very close. So when he reached out to his oldest brother about this will, he got no communication back, which was unsettling. At some point, he was asked to sign a blank document that his brother sent him. No communication still, just a blank document. Still no will. So after 6 months after his father's passing, he sent his own demand letter to his oldest brother and said, hey, you need to send over a copy of Dad's will. I need to see it. He still got no communication. He came to our office and he didn't know what to do, but Andrew's been helping him through that, one of our attorneys, Andrew, and he had a really good strategy.
Yeah, absolutely. And Andrew's fantastic with this. He's been a litigator for a long time. He's got plenty of litigation experience. And so when you get into a dispute like this, that's what you want. And you want someone who's going to take a look at a case in a very structured and methodical way. And he brings that. He brings that to the table. And so here, I think this is great because you've got a client that has really tried everything they can think of to handle the situation, and they just hit a brick wall. Even to the point of sending their own demand letter to request a copy of this will, and they're still getting crickets. And so I know that I know you've been on calls where we get these kind of calls all the time from folks, and so they're just at their wits' end. And what do I do? And so here, Andrew started with the basics. Like we do, review what the client had sent, review, any information that the client has regarding the situation. And then he decided to conduct an investigation. So he calls the probate court. We're going to check and see if anything's filed. Found out nothing had been filed. And so then he decided, in consulting with the client, let's reach out to the other side, see if he can get traction where the client was not. And so his interaction, with the other side, and I think he sent a letter. I think he sent a demand letter as well as a phone call. Kind of made the guy nervous. So we realized at that point the other party did not have an attorney. He was one of those situations where it's kind of like, I'm in charge and I'm going to do this however I want. And if I don't want to give you anything, I don't have to. Well, that's not true. Mm-hmm. And so Andrew, because of Andrew's actions, this other party winds up getting an attorney. And then Andrew's able to converse with the attorney, and we're able to get very quickly a copy of the will so that our client can see what's in it. We can see what's in it. We can advise the client. It turns out the client gets a 1/5 interest of whatever's in the estate. And so the client had an absolute right to see that will and participate in that estate. And so, what I think is interesting here that I wanted to highlight is a lot of times, you might think it's better if the other side doesn't have an attorney. You're going to steamroll them. And that happens plenty of times, right? Unrepresented parties, that happens. Sometimes in a dispute like this, it's actually better if they get a lawyer. Because then their own lawyer can tell them, you have to turn over this document, right? And that just saves our client the time, effort, and money of having to litigate this, because we'll get the will. I mean, that's not a question, but it's the steps and the process we have to go through to get it. And so having, Andrew's strategy work out where the other side hired their own counsel and then could listen to their own counsel, tell them, you need to do this, then we get a copy, our client's happy, and we didn't have to engage in extended or protracted litigation to get it done. I think that's a huge win for the client and for the process.
Most definitely. So what if, when Andrew would have reached out to this client, this opposing side, and they did not respond or anything, what if they just continued to be uncooperative? What could we have done then at that time?
Oh, that's a great question. Yeah. So that's a great question. So I think what I would have liked to have seen if that had happened is, we reached out, we did the phone call, we sent a letter. We're being reasonable. You always want to be reasonable in situations, and we would have established a deadline with the party, and then they violate that deadline. I think the next step would have been filing a petition with the court. You can file a petition to compel the production of the will. There's actually a law in Georgia that says if you are in possession of an original will, you are required to deliver it into the hands of the probate court clerk. And so we could have utilized that statute to file an appropriate petition in the probate court and require that party to file the will with the court of record. Once it's of record, we can get a copy, we can see it because it's public record. And so I think that's what I would have liked to have seen had we gone down that road. And then at that point, depending on what the will says, we would have prosecuted it further on at that point, depending on when that party filed the will. Whether they filed it just for informational purposes or whether they filed to become the executor of the will. Because, obviously, if we're having to fight you just to give us a copy of the will, we really don't want you to be the executor. That's a pretty good sign you're not going to do a great job. And so we probably would have advised the client at that point that this person shouldn't be the executor. we need to fight them on becoming the executor because, yes, it's a fight now, but by having the fight now, you probably stop 2 or 3 fights down the road. So it's a net positive benefit to the client. And you also stop any kind of shady business that person would have engaged in. And as you and I have talked about many times before, it's always, you're always better stopping something from happening than trying to put it together after it's broken.
That makes sense. Most definitely. And I was thinking as you were explaining all that also, so a question we get a lot on the front end on the consultation is, well, do I even have a right to see the will? You mentioned a little while ago that as a beneficiary, he had every right to be able to see the will. But even going into it without knowing yet if you're a beneficiary, I guess that would say in a way you should be able to at least view the will to understand if you are or are not a beneficiary. Wouldn't that be right?
Yeah, we've got a pretty so what you're talking about is an interested party. We've got a pretty expansive definition of interested party. Okay. Every heir is entitled to a copy of the will, whether they're in it or not. Beneficiaries are entitled to a copy. A will is not like a secretive document. Mm-hmm. Once it gets filed in the court, it's public record for anybody that wants to look at it. Like I could go, you could go, anybody could go look at it. And so, but in particular, if you're either a beneficiary or an heir, it's not like it's a higher standard, but in a way it is, right? It's like, come on, this person has an absolute right to see it because they're impacted by it. Mm-hmm. The heir is impacted because if that will is presented to the court and that will is accepted by the court, it could change the heir's rights, right? Heir means someone who would inherit when there is no will. So if I stand to inherit a portion of the estate, if there's no will, and a will is presented that cuts me out, I have a vested interest in understanding whether I think that will is valid or not, because it's going to affect me directly. And then beneficiaries, I think, is even more obvious. If you're a beneficiary of a will, you're getting something from a will, you have a right to know what you're supposed to be getting so that you can verify you're getting what you are supposed to get under the terms of the will.
Yeah. Yeah, that makes complete sense because just like we were talking about in a previous episode, it sounds like this older brother, who is named the executor, it sounds like in this will, was being more uncooperative. Yeah. So if this were to hypothetically go to court, those things that he was doing before, I would assume, as far as not communicating and things like that, that could be brought up against him later on, right?
Yeah, something? Absolutely. Particularly if, we talked about, I mentioned challenging that older brother to say, hey, he should not be the executor of this estate. All of that evidence is absolutely relevant. Yeah. And we would absolutely want to bring that up to show a pattern of conduct, to show this is where his mind is, and to show we do not think this person's fit to be the executor. We need someone else here that's going to handle the job the way it needs to be handled.
Exactly. So summary there, executors communicate. And if not, we have options for that basically at the end of the day.
Yeah, absolutely. If you're an executor, just communicate. Don't try to play hide the ball. That always gets you in trouble.
Yeah, makes sense. Wow, what a win and a relief for our client. I mean, this is the good legal work that our team does every day for our clients. And it's great to hear some of these stories and some actual big wins that our team has helped our clients with. Yeah,
absolutely. I mean, there's plenty more, but these are just some highlights that I thought would be cool to talk about. So thank you for putting that together.
Yeah, thanks, Eric. Thank you guys again for listening to our episode today. If you have any questions or comments, please comment below. We may use that in a future episode. If you have a specific situation that you'd like to discuss with us, please reach out to our office and we'd love to discuss that with you. Thank you.
Thank you.